Even during the pandemic, we have reached out to our partner
our people, our country, and our world. We seek your guidance. We seek your inspiration so that at the end, what we do
Amen. Thank you, Member Jackson. Do we have any apology for absence? I have not received any.
Member Scott Motley should be on her way.
I believe the member has joined virtually.
Madam Chair, different virtually from 10. It is just that Member Jackson would desire my presence in the chamber, and I assure him that on the next occasion I'll be there.
Very well, very well. All right, so we have no apology sent in. Permit me, therefore, to welcome back all members and the supporting staff to this important Joint Select Committee meeting. I trust everyone had a Merry Christmas, good holiday season, and that the new year will bring many blessings. It's a time when we make resolutions and we try to turn new pages. It is my hope that this year will bring us a lot of blessings, good reflection. It is what comes with the season. All right, we have 3 sets of minutes for confirmation. Any matter arising from those minutes. And then for new business, we have the matrices outlining the submissions of the different entities that have presented to the committee. I want to thank the clerk and the parliamentary staff for working assiduously to get the matrix out. I know that it took quite a bit of work and time, particularly because of how some of the presentations were made. But I think everyone had them at least a week before today's meeting to allow for time to be refreshed, for your memories to be refreshed, and also to go through. So let us proceed with the reading and confirmation of the minutes for meeting held on December 13. On page 1, paragraph 1 reflects attendance. Is there any correction to paragraph 1? There is none. Paragraph 2, call to order. 3, prayers. Meeting, we are taking them in chronological order, starting with the minutes for meeting held on Tuesday, December 13. Member Scott Motley, is there a hyphen between Scott and Motley?
Yes, there is, Chairman.
Right. See, there is none between Malahoo and Fort, and I know sometimes persons writing add or subtract. Please note the correction. to Scott Motley. So if there, other than the insertion of the hyphen between Scott and Motley, if there is no other correction to page 1, may we move for confirmation? Page 1. Am I to take the silence as consent? We will come back to an overall confirmation. Moving to page 2, paragraph 5. Paragraph 6. Paragraph 6 really should read that okay, maybe we had not set a date. We had deferred confirmation of the minutes of meeting of the 6th to, I think, the 14th. The 14th. Right, so paragraph 6 would read confirmation of the minutes was deferred to Wednesday, December 14. Paragraph 7. Only correction I see is a typo. The word justices and the word peace should be capitalized. And I just say that wherever they appear in the minutes, they should be a capital J and a capital P. Any other correction to page 2? Paragraphs 5 to 7. There be none. We can move to page 3. Again, the only correction I'm seeing is to justice of the peace for the capitalization of the word. Page 4. If there is no correction to page 4, we can move to page 5. If there is no correction to page 5, we can move to page 6. No correction, page 6. We can move to page 7. On page 7 in the paragraph, bail after conviction, the Regina and Rudolph Henry should actually be, instead of the and, it should be a V for versus. Though said and, though read as and, it's actually Regina against, so it would be written Regina. and United Kingdom Supreme Court. Court should be capital C. All right, if there is no other correction there, we can move. Page 7. No correction to page 7. Page 8. May someone move for the confirmation of the minutes as corrected?
So move, Madam Chair.
Thank you, Member Rodriguez, Campbell Rodriguez.
Madam Chair, can we also ask that for ease of reference, can the minutes, the pages of the minutes be numbered? It's simple, but
you
to
read
make,
my mind.
yes, to make life much easier.
Yes. Madam Clerk, please ensure that the pagination appear on each page. And I actually like the format which says 1 of 3, 1 of 2 of 4. Yes. Seconded by you, Member Jackson. All right, we can move to the minutes for the meeting held on December 14. Paragraph 1, attendance. I think Scott Motley to be hyphenated. Right, if there is no correction to page 1, we can move on, other than the form of Member Scott Motley's name. All right, so these minutes are not numbered in paragraph as the previous one, so we would also ask that the numbering of the paragraphs and the pagination be standardized. Apology for absence. Confirmation of the minutes of meeting held on Tuesday, December 6. Matters arising. New business, clause by clause review. If there be no correction to page 2, we can move to 3. Definition of deciding official. Definition of defendant. there be no correction, we can move to page 4. There is no correction to page 5. We can move to page 6. Chief Parliamentary Counsel should be capitalized in the second paragraph. If there is no correction to page 6, other than in respect of CPC, we can move to page 7. If there is no correction to page 7, we can move to page 8. The third line in the second paragraph, the bill should be a capital B. Joint select committees, should that be capitalized also? Yes. I think the government, having proposed a policy, must defend the same. Support? I think it was defend. Paragraph dealing with definition of surrender to custody. Right. If there is no other correction to page 8, we could move to page 9. If there is no correction to page 9, we can move to page 10. Clause 6, grant of bail after charge prior to conviction. Clause 7, circumstances where bail may be denied. If there is no correction to page 10, we'll move to page 11. If there is no correction to page 11, we can move to page 12. Closing remarks. That should be formal criminal justice system. Formal criminal justice system. All right. If there be no other correction than those pointed out, would someone move for the confirmation of the minutes? Members Rodriguez Campbell and Jackson. Member Rodriguez Campbell, there is a hyphen between your Rodriguez and Campbell? I see. Do forgive me for Campbell Rodriguez. Yes, Campbell Rodriguez. Right. Like I say, there is none between Malahoo and Fort, because there is no Mr. Malahoo Fort. Date of it, 2023, January 11. Yes. All right. So the minutes of meeting of December 12th and corrections made confirmed by member Campbell Rodriguez, seconded by member Fitzjackson. Move to the minutes of the meeting held on Thursday, December 15. Page 1, paragraph 1, attendance. Call to order. Prayer. You've been praying quite a lot, Member Fitzjackson. Welcome and opening remarks. Apologies for absence. All right, other than the hyphen, insertion of the hyphen, and I would just say to prevent repeating that for all the minutes to be corrected, where a hyphen are to be inserted in the double barrel names, that the hyphens be so inserted, and where they are not to be, they're taken out. All right, there be no correction to page 1 other than hyphenating. We may move to page 2. So I noticed that page 1 starts with a paragraph 1 of attendance, but I don't see that carried through to the other paragraphs. Just to standardize the form of the minutes to include numbered paragraphs and paginated pages. New business, clause by clause review. Clause 8, conditions of bail. Next paragraph, beginning Senator Campbell Rodriguez. Next paragraph, again beginning Senator Campbell Rodriguez. Next paragraph, beginning Member Williams. Is there a reason why the Member Williams is stated and not Member Campbell Rodriguez, Senator? Just wondering about the standardization, because normally the... Sorry? Yes. Yes. They distinguish this. Well, I actually thought that in the case of the committee, all members are members of the committee and are referred to as such, notwithstanding that a member of the lower house is a member of parliament and a member of the upper house is termed a senator. But I thought for committee purposes, right, our members. Well, I'm just concerned with what is correct. Because you definitely are not left out, yes. But we can check it. It's some people may think that it's unnecessary picking, but I think accuracy matters. And it's important that if we're ignorant, we gain knowledge. Sometimes many go through membership in parliament not really knowing what is correct, because so many things deviate from what is really correct, and the frequency with which the deviation is repeated cause those who would not take the time to seek out the knowledge to go away believing that those malpractices are correct. Right, if there is no correction to page 2, we can move to page 3. Member Charles, that paragraph. Next paragraph, Member Williams. Paragraph commencing clause 9, general provisions relating to bail. Paragraph the chairman said. Paragraph commencing clause 9, recording and giving information on bail, on decision concerning bail. If there is no correction to page 3, we can move to page 4. Top of the page. Then the next paragraph, Member Jackson. Next paragraph again, commencing Member Jackson. Right, if there is no correction to page 4, we can move to page 5. Paragraph commencing Member Williams. Paragraph commencing clause 11, review of bail decisions. Paragraph commencing clause 12, appeal from decision of judge. There is no correction to page 5. We'll move to page 6. Clause 13, bail after conviction, second schedule part 2. Is that a 2 or an 11? There, that looks like more 11 than what would be used for the Roman numeral 2. Paragraph commencing member Jackson. Justice of the peace to be capitalized. And same for justices, because it's the proper noun as defined. Paragraph commencing clause 14, absconding by person released on bail. Parish and Supreme Court should be capitalized. Paragraph in ensuing discussions. Paragraph commencing clause 15, liability to arrest for absconding, breaching conditions of bail. If there is no other correction to page 6, we could move to page 7. Paragraph commencing member Williams. Next paragraph, member Jackson. Commencing member Jackson. Paragraph commencing clause 16, bail on surety. Paragraph commencing clause 17, forfeiture of security or recognizance. Paragraph commencing clause 18, release of surety or refund of payment. Clause 19, clause 20, 21, 22, 23. There is no correction to page 7. We move to page 8. Clause 24, first schedule, second schedule, third schedule. You see the difference with the 2 there, as opposed to the 11. Memorandum of objects and reason. Closing remarks. Justice of the peace, again, capitalized. Date of next meeting. All right. Will someone move for the confirmation of the minutes as corrected? Campbell Rodriguez.
Seconded.
Yes. Member Dr. Michelle Charles, seconded. Thank you. All right. I know we have gone through 3 sets of minutes, but I will ask, is there any matter arising, firstly, from the minutes of December 13? All right, if there is no matter arising, any matter arising from the minutes, the meeting, December 14. If there is no matter arising, anything arising from the minutes of the meeting of December 15? There is none. All right, no matters arising from the minutes. We move to new business. New business involves a review of the matrices. Actually, it's one matrix in 2 parts. All right, just asking everyone to turn attention to the matrix of submissions for the Joint Select Committee, the Bail Act 2022. So the matrix sets out the clauses, description, and then we see those who have made submission. So we will start with the thicker document. I think that's the first part. Madam Clerk? I welcome suggestion from any member and supporting staff as to the most effective way of going through the matrix.
Madam Chair, I noticed that the two matrices that we have, the smaller one is from individuals and the bigger one is from organizations. Is there a reason we're starting with the organizations before the individuals?
Right. I think that An individual is also inserted in the one that appears to be from the organization. I don't get the sense that that was deliberate, only a convenient way of setting it out. But I welcome suggestion from members and supporting staff on the most effective way to review them.
Madam Chair, just noticed that the smaller one, I'll also refer to it now as the smaller one, since it's not only individuals, it's only general recommendations. No specific clauses are included in that one. So I'm wondering, since the other one starts with general recommendations as well, if we could just, since this is only just general recommendations, I'm suggesting that we start with the smaller one just to keep the general recommendations and then clause by clause.
Thank you for the suggestion for consideration by the committee.
Chair, perhaps going all the general recommendations, both the larger document and the smaller one, maybe because you don't want to do general, then there's just a little bit for one
The
of the
suggestions are that we deal with
Just the
all
gen-
general recommendations, whether they are contained in the matrix,
Yeah.
the smaller matrix or the bigger matrix,
Yeah,
just to look at the
because
general
after that, it's just
recommendations.
clause 5 that
Yes.
there's only clause 5, yes.
Miss Wilkins, may I call upon you to do the reading then? Madam CPC did the clause by clause, but since this is your ministry's bill also, right? To just take us through.
I'm sorry, Chair, you want me to read the verbatim, the recommendations, each one of the recommendations? Okay. Starting with the small one. Aaron Douglas. After carefully reviewing the material, I've noticed that there is no use for bond shops in our court system economy, which can seamlessly operate in our judiciary and rake in new bond tax and license fee revenues in the government's coffer. Allow me to indulge my imagination here. Such newly created bond shops could be tasked with creating and maintaining supply chain of electronic monitoring devices under government's official supervision, thus easing financial burden on the government to provide such. In addition, this would require the privately owned bond shops to put up assets as security. There are other nearby jurisdictions up north and elsewhere where a study can be conducted to determine its suitability in Jamaica. That is Aaron Douglas's only recommendation.
Recommendation in relation to bond shops.
Yes.
What is the understanding of this recommendation? That the law provides
For bonds,
A
we
commercial-
have an express provision that would not allow
create a commercial
for, yes.
arrangements for bonds?
We
Member
have-
Jackson?
Yeah, my understanding is that in other jurisdictions, I know in the US, I don't know about the UK,
Where is it again? We have
that
it here.
there is commercial offerings of that service. I guess those especially who operate
Is
at
it
the criminal
19?
bar
19.
can better advise. Somebody is charged, arrested, need to get a bail. They can't find somebody who was either willing or what have you to come up. And there's some commercial offering that they can purchase that I don't know offhand what are the technical requirements of somebody being a surety in a bail where such commercial offering might negate it. But if so, I think the gentleman's proposal is that isn't it something that we should consider for those persons who would want to access bail but can't find a relative or family friend who is willing to put up anything. And I think too, guided by you all who operate in the court, that the court might want such surety in a form that he might not be able to present, he meaning the charged person, might not be able to present, but the bonds entity would be able to take a letter or whatever it is, a surety for them to be surety to the court. And
Under clause 19, it is an offense to seek to indemnify or offer or agree to indemnify a surety against the possibility of loss arising from the absconding of a defendant. Yes, so we have statutorily.
So our law goes in another direction. The concern you raised about ensuring that a person who is granted bail is able to take it up is provided for through own surety, as opposed to having to find. So the scheme that we have and what currently obtains in the jurisdiction under the Bail Act now has given thought to that and provides not only for bail with surety, but also bail without surety or in own surety. So having regard to what we're monitoring, I don't know that we are there yet. In fact, those who seek to commercialize the bonding system have created more challenges than assisting the matter so far. But I do understand, where the recommendation is coming from, because there are other jurisdictions, particularly in the U.S., I think, in some states that have gone in that direction. But it is not now our policy. And yes, but right. So you would look at, I just invite you to look at the provisions for surety here, and you would see the policy approach that is taken, right? Set out at clause 19, page 25. So whereas the proposal here focuses on the commercial interest and creating an industry around that, our focus is ensuring that anyone who is granted bail actually returns to stand trial because of the duty to surrender to custody. So our focus is just ensuring that we do not have commercial considerations given priority over the justice consideration of the person returning to stand bail and the liability that would flow to a surety. That mic sometimes give trouble, Member Jackson. That's the seat I sit in the Parliament, and I know the. No, no, that's my assigned seat, and I know there's always some concern with the mic there. Your mic is off now. The mic is off now.
It's on now?
Off. I think you have to push. Yes.
Control over there. Where was I again? Who's my trainer talk?
So let's bear in mind we have a number of contentious matters
yes, I was
to consider. So how we use the time
Yeah.
for deliberating on it. So if the initial concern is to ensure that where bail is granted with surety, it's not made more difficult for the person to take up the grant of bail, I just invite you to take a look at clause 16, clause 16.7, clause 16.9, page 22. 9. So provision is made where they're unable to be released because no surety or no suitable surety is available. So built into the law is a consideration in that regard. And it's always open to the deciding official also in an appropriate case. Bail may be granted without surety in an appropriate case. All right, so that is considered. Right. All right. So I think considered but not accepted, we could say, in respect of this recommendation. Right.
This one working.
All right. Proceed.
Jordan Jarrett's general recommendation. It is being proposed that a definition of bail should be included. Rationale. Firstly, the proposed Bail Act 2022 largely overhauls and redefines bail practice and procedure in Jamaica. With relative novelty, the proposed act intends to make bail available during the investigative stages of the criminal process, and not only after an accused person has been charged or convicted, and as is the traditional position. The substantial changes to the bail regime, in my view, beget a clear definition being included in our new Bail Act. Secondly, while it is neither usual nor necessary to define all the words or phrases contained in a piece of legislation, definitions help to clarify the scope, objects, and purpose of a piece of legislation, thereby improving the accessibility of legislation to the courts, lawyers, law students, and other stakeholders. Relatedly, the insertion of a definition is an opportunity for Parliament to reduce the need for judges crafting their own understanding of what bail means in the context of the legislation. In the case of Lascelles Gardner and Horace Ellis versus the Crown, the Court of Appeal, in the absence of a statutory definition of bail, had to forge its own definition, relying on a dictionary and other sources.
Let us, I'm sorry?
Okay, continue. There's no...
That's the same, there is a, sorry? Yes. All right, we open the discussion on this proposal for the inclusion of a definition of bail. Mr. Foreman, you want to weigh in? Oh, afterwards. You would prefer to speak after? Very well. Members?
Madam Chair, as is reflected in the minutes of December 14th, it's an issue that I had raised. And so I'm still in support of this recommendation. Even with Ms. Grant's, I think it was Ms. Grant who had given her opinion on the matter. But as we said, we'll discuss it here. But I'm still in support of the need for a definition of the term bail.
Any other comment from any other member? Then I shall ask the Learned Assistant Attorney General, Mr. Foreman, to weigh in.
All right, thank you, Chair. While I can understand and appreciate.
Speak in the mic for
is this fine? All right. I would have some concerns about defining it.
Mr. Foreman, may I just ask you to speak a little closer to the mic or bring the mic a little closer to you?
There would be some, on one side, there would be some challenges in defining it. On the other side, it might not be necessary at all. So on the side of potential difficulties, the Constitution itself in Section 14.4 just refers to bail without providing a definition. And in the context where the Constitution itself does not define the term, purporting to do so in ordinary legislation potentially gives rise to problems down the road if the court is trying to place a definition on a constitutional provision while the ordinary statutory provision is at variance with that. Secondly,
I just ask, are you saying that where a term appears in the Constitution but is not defined there may be difficulty in defining it in ordinary law? Is that a general statement?
There could be. And there's a term for it that's skipping me at the moment. But there are other things that...
But the Constitution wouldn't go into details. The Constitution at the highest level provides guiding principles and sets the parameter also. I'm really asking because I know you, it's an area in which you have some specialized learning.
There's a term for it, and there's a case actually from our jurisdiction where an issue arose regarding whether I think an ordinary piece of legislation was either purporting to, or the argument was...
This is in relation to rights-related provisions or generally?
I think it was generally. I don't recall precisely. I'd have to look back at it.
So, for example, you have another term in the Constitution about competent legal authority. Those can be specified. I mean, would we run into difficulty because the Constitution may not, a competent legal authority defined by law.
Right.
One would expect that for the purpose, ordinary law would say who is.
Right. Not clear if in a specific situation like that you would be defining the term or indicating for the purpose of a particular legislation what is included.
I really am interested in getting as thorough an understanding of the point, but let's go back to bail.
I think the substance of the concern would be the potential for limiting.
So a definition has the consequence of limiting something.
The potential consequence.
The potential consequence of limiting
I want to
provision.
be very careful with this one, having not looked back at that. But the other point on the definition side is that there are essentially two bail-related provisions in the Constitution. One is 14.4 and the other is 14.3A2. And 14.3A2 speaks to release either unconditionally or upon reasonable conditions to secure attendance, and it goes on, and that language seems clear enough in terms of what can be done. That placing a definition there might be odious, might be unnecessary. This second reason to perhaps resist it is that the term is already understood, both at common law and in practice. So that if normally when you define something, you maybe want to depart from an existing understanding, or you're creating something new and you want that to be understood clearly. in a situation like this, that does not arise. The third point I would make is that in the case that was cited, Lascelles, Gardner, and Horace Ellis against the Queen.
Mr. Foreman, still asking you to speak a little more audibly.
Right. So in the judgment that was cited by Mr. Jarrett, in paragraph 38, the judge there more or less said that there really is no need to define it. Right. So in paragraph 38, the judge says none of the statutes to which counsel have referred define bail. However, in my view, there has never been any confusion as to what bail means in court proceedings. So the court itself there was acknowledging that the concept is understood. The judge nevertheless went on to look at various ways in which people have defined the term. And the last point I would make is that while this case is one written by a judge of a judge of the Court of Appeal, it was not the Court of Appeal itself. So it was a single justice of appeal sitting in chambers hearing a bail application. So it was the Court of Appeal, properly speaking, consists of at least three.
So for the non-lawyers, you are raising the point that the force of this authority would be questionable in the context because it is not a judgment of the court, but of a single judge of the court.
I would use the word questionable. I think the reasoning is fine. I would say it's not as forceful as it might have been if it was authored by a full court, the Court of Appeal as properly constituted. So for those reasons, I don't see an actual problem that needs to be fixed, a mischief that needs to be fixed, and attempting to fix that mischief might give rise to other problems which we might not need to enter into. So I resist the recommendation on those points.
Can I ask a question, Madam Chair?
Member Campbell Rodriguez.
Question, Mr. Foreman, because my agreeing with this suggestion and having made it myself stems really from the first rationale that Mr. Jarrett gave. Didn't have anything to do with the Court of Appeal or anything, but more so the fact, because you stated that there is a general understanding in the common law and otherwise as to what bail means. But with this new overhaul of the Bail Act, I don't think we can say there's a common understanding of what bail is within our jurisdiction. And as he pointed out here, the substantial changes to the bail regime beget a clear definition. So based on what you have said and what the new regime is, there's a little gap there because there isn't that clear understanding of the average person or even the legal fraternity as to what bail is. That's what we're doing with this Bail Act, changing the regime.
I'd respond to that in two ways. One, the substantial changes the bill introduces, in my view, are more so related to the language and structure of the legislation, streamlining provisions and the like, as well as the inclusion of the...
Mr. Foreman,
as well as the
please remember we have to hear you.
Right.
I'm struggling to hear you and I don't
Right.
know.
Yeah.
Yes, but...
in my view, the substantial changes, right? The substantial changes don't relate so much to what is meant by bail or what is understood to be bail. But
response is true even for the provision of the grant of bail before charge?
to the extent that it concerns release either unconditionally or upon reasonable conditions, which is the term that the Constitution itself uses. That's the idea that's there. What I understand the bill to do in the pre-charge context is to extend the concept of bail to situation that it previously did not extend to under the existing legislation. And beyond that, the substantial changes are streamlining language, clarifying certain things, extending some provisions, limiting others. So to premise substantial reforms as a basis to also introduce a definition, the weight of that, in my view, is not significant for the purpose of a definition of bail.
Just to be clear, you're saying that by extending the provision for bail to cover what is also provided in the Constitution for a release either conditionally or unconditionally for either trial or a subsequent stage in the proceeding is not necessarily adding newness, it's just expanding it. I'm just trying to be clear.
In relation to
the pre-charge regime,
yes.
Right. And to the extent that the Constitution explicitly provides for the release of someone, either unconditionally or unconditioned, not only for trial but for later stages of the proceedings, indicates that, well, you can finish it. That it's a mere extension.
My point in that respect was that
yes.
Those words seem clear enough in terms of what is contemplated.
So those words would cover the situation of the grant pre-charge.
Yes, I would say
right.
so.
Okay.
Yes.
I see.
Maybe including that language. Might
right.
be something to consider.
Including what is there for a definition?
No, in place of the reference to bail in the pre-charge section, but I maybe raised
Got you. Right. So what I gather you're saying is that because the Constitution, tell you what, let me hear the response from the CPC, and then we can just discuss a little further. Madam CPC, I see your hand is up.
Yes, thank you, Chair. I just would like to support fully what Mr. Foreman had said. I don't know if the term he was searching for was ultra-virus, but certainly insofar as this act, or this bill rather, is purporting to treat with bail based on what is provided for in the Constitution, then insofar as the term bail is not defined by the Constitution, this act could not put forward a definition of bail for the very reason that it could be construed as ultra-virus in the event that the reference to bail in the Constitution is interpreted as having either a wider or narrower meaning than the definition that would have been proposed in this bill if the recommendation is accepted. So basically, it's a very risky proposal. And also, if the Constitution intended, by not defining bail, for it to have its ordinary meaning, then certainly the bill would have to be consistent with that.
Chair,
Yes,
I
Ms.
just
Wilkins?
want to point out that it is, I think, for these very issues that the existing law define bail in criminal proceedings, because the word does have several meanings, and in order to ensure that it is understood how it is to be construed in the law, the existing law does say what bail in criminal proceedings is intended to cover, and it covered all the scenarios, including the pre-charge scenario. So I don't know if it is something that we could go look at again, and that it would settle the issue, I think, if we were to perhaps I don't want to step onto the CPC's domain, but perhaps something akin to what is in the existing law would address the concerns.
Madam Chair, if I might.
Yes, Madam CPC.
Right. That definition in the existing act about bail in criminal proceedings doesn't really speak to bail. What it really does is attempt to define proceedings. So the bail, the reference to bail there is incidental and does not really speak to what bail is. And again, in my view, that the purpose of that whole definition of bail in criminal proceedings was really to really serve the purpose of avoiding including in the definition of defendant a person who is has been arrested or detained but who has not yet been charged. That was what that scheme did. It doesn't really speak to what bail is.
Right. So when we did the assessment, I think we agreed that what the current law provides for without fleshing out the provisions was the grant of bail at different stage of proceedings. And so in that provision for bail in criminal proceedings, you would see a reference to a pre-charge situation, stage of proceedings. And that actually now ties back to what is provided for in the Constitution, because the Constitution does not restrict it only to trial in respect of the conditional or unconditional release of persons. So I would say that the CPC made a point in the meeting of December 14, and I think sometimes that point is not sufficiently understood. The matter of drafting of law, the drafting of law, requires technical expertise, specialist expertise, even if generally we may think that, because by virtue of our general learning, we can draft. And how we provide for matters in a law has consequences for the overall scheme of the law, how the law relates to other things, the statute law, how it relates to the common law, whether a provision is modifying the understanding of the common law, because statute law may also completely abolish something in common law, or it may merely modify it. It may codify it. And so beyond what appears logical to us, there are technical expert matters that have to be considered. It is not the intention of this bill to change the common law understanding of bail. The extension of the bail regime to a pre-charge defendant is, on our understanding of the constitutional provision, permissible because of the guidance given by the court on how to interpret rights provision and the dual provision in the Constitution in relation to the entitlement to bail and the mandate to release a person who is detained either conditionally or unconditionally, to enable such a person to either return to trial or another stage of the proceedings. And for the criminal purpose, the proceedings are not just, the proceedings include the investigation side of it. We did not define it because we did not intend to modify the common understanding of it. But I appreciate the recommendation which says because we are overhauling, providing a definition may be helpful, but that is countered against the consideration of whether in defining, providing a definition, we may do more harm than good. What are we? Foreman? Yes.
So I have nothing further.
So, Ms. Wilkins, you want to weigh in again? So it
Yeah,
seems...
well, I don't think there's any disagreement between myself and Mr. Foreman that the term should be defined. We don't think it should be. I was only drawing your attention to the fact that in the existing law, they didn't define it either.
Right.
But what they did was to put the context within which it is used in the law, rather than try to define it. I don't think it's useful to define it.
All right. Unless there is a dissenting voice, I would say we could be guided by the considered view of the chambers and the Law Reform Division, the CPC, take into account the clarification provided and not accept the recommendation for the term to be defined.
Okay, so another recommendation from Mr. Jarrett. The inclusion of a broad obligation to produce the reasons for adverse bail decisions is welcomed. Recommendation. The following are being proposed on post-conviction bail. Post-conviction bail should be available in appeals against sentence, even if in very limited circumstances. The inclusion of the exceptional circumstances threshold for post-conviction bail is welcomed. There should be no limitation on the type of offenses that qualify for post-conviction bail. Rationale. The source of the Court of Appeals' power to grant bail after conviction, otherwise called bail pending appeal, is the combination of the Judicature Appellate Jurisdiction Act and bail legislation. Outside the powers granted by those enactments, the Court of Appeal has no inherent power to grant bail. Careful attention must therefore be paid to the provisions surrounding the grant of bail after conviction, as they entirely circumscribe the Court of Appeal's jurisdiction to grant bail. The need for care in the crafting of provisions relating to bail pending appeal is emphasized by the fact that several courts have held that deficiencies in a comprehensive legislative scheme can negatively impact the enjoyment of fundamental rights and give rise to successful claims for constitutional relief.
Any comment from any member on that proposal?
What is the issue with the post-conviction?
Any comment from any member? Right, so this recommendation
yes, that's what I'm wondering.
Is asking for a provision for the availability of bail pending appeal, not just against conviction, but also against sentence. Now, since the recommendation was made, I did a little research and get a sense that there are a number of matters before the court where the real issue is the sentence, or no, let me start again. That not providing for bail pending appeal against sentence could have the unintended consequence of convicts lodging an appeal against conviction just to satisfy the criterion to get bail pending the hearing of their appeal, when the real issue is with a sentence, and in some cases there is a likelihood of a sentence of where they are not required to serve a term of imprisonment. So the rationale for the current scheme is that once you are convicted of an offense which carries a sentence of imprisonment, your liberty is properly and constitutionally forfeited in those circumstances. And there is no entitlement per se to bail. But recognizing that convictions may result from errors, fact or law, or any of the many grounds, and at the end of a process, a person may be acquitted, then the allowances made for the grant of bail to persons who were already on bail, who have filed an appeal, and while they are awaiting the outcome of the appeal. I am kind of still thinking it through whether we should include sentence, and how would we include it to ensure that we do not cast it widely. Mr. Foreman, did you consider this recommendation?
Chairman, I'd not given it a lot of thought prior to now, so I'd want to think it through a little bit more.
I ask that you just flag it for further consideration. Ms. Wilkins, you have given consideration to this proposal?
To be honest, I was trying to identify the gravamen of the issue that is being raised, whether they feel that Clause 13 is too generally worded. I'm trying to understand. They weren't very specific, and I must confess that I'm not quite sure that I appreciate the danger that is being pointed out. So I don't know. Honestly, I'm not sure. What is the issue?
Madam CPC? Oh, sorry.
No, I'm just looking at... Let Madam CPC speak.
Yes, Madam Chair, I must confess that I hadn't also given it a lot of thought. But if it's an appeal against sentence, then presumably the person is appealing against perhaps the length of the sentence. I'm not sure then what is the harm in not giving that person an entitlement to be out on bail in the case where that person would, if the appeal is against merely the length of the sentence and not necessarily against the conviction itself, the person would have been then imprisoned. So I'm not sure what the harm is there in that case in not extending a right to bail in those circumstances.
All right. May I just say for our technical team, I'm sorry?
Sorry, Minister, but if the appeal is against sentence, the issue of bail doesn't arise. It's appeal against conviction.
No, the recommendation is that the provision should be extended to include not just where there is an appeal against conviction, but also where there is an appeal against sentence.
No.
Right, that is the recommendation. So currently, the law provides for appeal against conviction. Right. All right. In the absence of any, not against sentence, because the thinking is that if you are sentenced to imprisonment, you really, after you've been convicted, the situation changes entirely. It's not a case where you're sentenced to a fine or so. this is where you're sentenced to a term of imprisonment and would be required to serve the term. Right.
Sir?
The provision.
Sir, may I just add, Chair?
Yes, Member Scott Motley.
Yes, I'm thinking about it. And I think that it deserves perhaps some contemplation. I'm thinking about if somebody is sentenced to 3 years in prison, 5 years in prison. And with the length of time that sometimes it takes for a matter, for an appeal to be heard, perhaps if the appeal is against sentence and the court takes a different view of what is appropriate, the time might have been served. So what the person was recommending is that in exceptional circumstances that could be looked at. I don't think we should dismiss it. I think it deserves a level of scrutiny.
Remember, no, the regime does not apply to a person who is in custody before conviction. It would apply to someone who would have already been on
would
bail.
Have been convicted.
Right.
Yes, I'm clear, Minister. Yes. I'm not.
Well, you would recognize from my own posture that I too am giving it some consideration. While we can properly keep it as is, I'm kind of thinking it over, because part of the rationale for some of the provisions is to ensure that we reduce congestion in the court as far as possible. So you do not have matters being placed in the court prematurely where they have to be on a mention list for an extended period of time pending completion of the file. And I wouldn't want to have persons appealing cases on conviction when really the bane of contention is with a sentence, and there is a likelihood. I would just ask that we defer this part of the matter for further consideration at this time. All right? And I would invite the chambers, the technical team, to just look a little more closely to see what, if anything, we may accommodate without doing harm to the overall policy.
Chair, but just for my own clarity, in light of what you're just advising or suggesting to the technical team, as I understand it, the current bail provision only provides for appeal against conviction, and this too, only against conviction. Where I was having some interest, and I think that's what Senator Motley was alluding to, while there might not be an appeal against conviction, but against sentence, and Sarah, if she choose some convenient time frame, 3 years, 5 years, not very long, and given the time it takes for these things to be resolved in the court, by the time you get around to the appeal, the man would have served the 3 years, so it becomes null and void. If you feel the sentence was unreasonable or what have you, whatever the substantive basis there could be, and you want to appeal it, by statutorily prohibiting bail, you would statutorily prohibit the court's intervention in the sentence that was handed down. And that's what you want to provide.
So the matter is not as simple as that, since the right of appeal granted to the Crown, because if the law provides for a particular type of sentence, it will be unlawful for the court to hand down another type of sentence that is not provided for. So if the law prescribes a sentence of imprisonment of varying length, it wouldn't be open to fine, for example. The law may provide for either imprisonment or fine or both. Yes. And in such a case, it would be quite permissible for the court to exercise its discretion and hand down either one provided for. Because we have had cases where the courts have handed down sentences that are not provided for the particular offense, it is now a ground of appeal for an unlawful sentence, for want of a better word.
So there is provision for...
Yes, appeal against sentence by the Crown if the court hands down a sentence that is not provided for in law.
Okay.
And then you have to also consider which would do greater harm. Because in sentencing, no, the court takes into account time already served in custody. That never used to be the case, because sentence used to run at one time from the date of sentence, not from the date of detention or remand.
But oftentimes I hear judges discount the time for incarceration,
time already spent in custody. But if someone has, so that's it. No, so you may be on bail for an extended period of time. It cuts both ways. And then at the end of the process, you have to go into custody to serve the sentence at the end of your process. So you weigh that against someone who would have been in custody. And at the end of the day, if you still have to serve sentence, you could be released because you'd have spent the time already in custody. So we will have to do a little more probing.
Is it a discretion of the court to discount the period spent incarcerated in the sentence?
It is now a practice of the court to do so.
No. So my question is,
yes,
is it a mere discretion or is it a statutory requirement?
No, it's not a statutory requirement, to the best of my knowledge.
Well, I think that would need some remedy. Why do I say that? If John Brown was incarcerated on a charge and was charged and incarcerated and spent 2 years in jail, either denied bail or unable to take up bail, but the fact is, his freedom was taken away for 2 years before a conviction, because he's presumed innocent until proven guilty. It goes to court, and in fact the court found him guilty, and say, for this offense for which you are found guilty, you will be incarcerated, you'll be punished by 3 years imprisonment. I believe it would be justice would only prevail if that punishment of 3 years deems plausible, justified by the court. And he already spent 2 years in jail, that it should be an automatic discount.
There are a number of...
I see the reason for it.
There are a number of nuanced consideration. So the right to liberty is not an absolute right, fundamental as it is, and heavily guarded as it is. Using the Jamaican Constitution as an example, it provides for circumstances in which a person may be deprived of his liberty. And the deprivation of liberty is not the same thing as a conviction at the end of the day. It's important. Hear me, Member Jackson. It is important, in spite of the sentiments, the human sentiments that flow when someone is deprived of their liberty. When we're talking about matters of law, no, we're all sensitive to that. And perhaps a little more sensitive in this jurisdiction, where, freedom matters. Whether it's responsibly or irresponsibly used, it matters and trumps a lot of things. But it is important that we understand that our own Constitution, and our Constitution is not unique in this regard, permits the deprivation of liberty in circumstances other than where you are convicted and sentenced to imprisonment. There are questions which arise about how is a person treated while in custody, what are they entitled to, and how long they should spend in custody, depending on the reason for the deprivation of liberty. So it's not an easy consideration. Now, people talk about the presumption of innocence, and I think sometimes, from what I hear, it appears that some are of the view that the presumption of innocence means that the person did not do the act that they were accused of. It simply means that you cannot convict the person without going through a process And that's a due process that it's linked to. And unless and until you go through that process, the person should not be at risk of becoming a convict. They may be at risk for other things. But in terms of a conviction, you have to go through a process. And the law, in its wisdom, recognizing that that process can be shortened if the person admits guilt. And that's why you have conviction by way of a plea of guilty or a finding of guilt after trial. But I think many times, once we hear about detention, people get very anxious without spending the time to properly understand the principles, even in this democratic society.
I don't think it's as simple as that, Chairman.
No, that's what I'm saying. It requires a lot of other consideration. So I remember when, I think it was Roshane Barrett, who was arrested for the quintuple murder in Clarendon, where there was unanimous outrage. I recall participating in conversations with constituents and other members of the society who, because of their outrage, felt that he should not, no lawyer should represent him. And in my own intervention in the conversation, I had to remind that the fact that he's presumed innocent does not mean he did not do the acts complained of, accused of. And it also doesn't mean that he should be deprived of the other entitlement, including the right to representation, etc., and everything else. So sometimes, in our raw emotion, we do not bring the kind of reason to bear on the matters under deliberation because, the issue is so clouded by felt experience around it. Right. All right, so we would just defer consideration of the recommendation to include bail pending appeal where the person is appealing certain types of sentences or sentence.
Well, not the type of, the unusual circumstances that would justify such a consideration would have to be developed.
We would also have to look at what would amount to the exceptional circumstance. Right.
And you may well find in looking at exceptional circumstances that these are things which even now a convicted person can make an application to the court for consideration, that they be allowed, for example, to serve their time in hospital or those.
And that has happened in this jurisdiction. And you can do that now,
exactly. So, it's not bail.
So
it doesn't come under bail. You
right.
have been convicted.
Right.
It's considerations as to what kind of arrangements can be made to facilitate your unique situation. It's not bail.
And Ms. Wilkinson, it's for that reason why there is a view that allowing the court that is manned by trained judges because it's not lay people who serve as judges, and you have to qualify at a certain level and for a certain period before you're placed in the position, to consider what is exceptional in the circumstances of the case before the court, having regard to the particular defendant or convict, the offense, antecedents, all things. So it's not an at-large consideration, but what is unique to the case before the court. But we have more contentious matters to deliberate upon, so let us move on.
Another recommendation was that there should be no limitation on the type of offenses that qualify for post-conviction bail, which would be that they would wish for the second schedule to be removed. That would be the net effect of that recommendation.
Well, it is not the policy of the administration to open that, because I can cite two examples where bail pending appeal is not in keeping with the policy of the administration. After conviction of murder and a conviction for gun offense, particularly now under the new prohibition, the new law, where the offense comes on the prohibition side, where the weapon was never entered into the system, it was traded illicitly, and for those. So I can say outright that an unqualified provision would not be in keeping with the policy of the government at all, just by citing those two examples. Further consider whether the recommendation for inclusion of appeal against sentence is to be included, and how.
Mr. Dwight Daly's recommendation. The following are being recommended. 1, I am of the view that defendants breaching curfew orders should be charged and not just taken back to court for a decision to be made. Violence producers are less likely to commit murders if they remain indoors during crime bans, 6 p.m. to 6 a.m. Currently, defendants complain that the police are making checks at their homes to determine if they are complying with curfew orders. As a result, some judges direct that this practice must cease, as it is illegal and borders on harassment. How can the police ensure that defendants are complying with the order of the court if they do not check? I am recommending that the Bail Act gives the police the authority to check defendants' residences during curfew hours to ensure that they are complying with the order. 2, the police normally complete a remand form, CR 14, which outlines reasons why they believe defendants should not be granted bail. This document is sometimes ignored by the clerk of court / Crown Counsel, and the information is not communicated to the judge. I am recommending that the Bail Act includes this form or the information contained therein as information that the court shall take into consideration when considering bail. That is some of their recommendation, that person's recommendation.
Invite comments from members on the first part of the recommendation. So just to say that the data presented to us by the police do speak to a crime ban between 6 p.m. and 6 a.m. when the majority of crimes committed on the island. So that is the data we have reviewed. There is really a time ban. The recommendation, as I understand it, is that where a curfew order is made as a condition of bail, the police, there should be an express provision for the police to check the residence of the defendant to ensure that they are complying with the order, because when the police make those checks, they are met with complaints of harassment. For my part, I wonder whether it's a matter of how the checks are made or the fact that checks are made, because the police must carry out their duties of ensuring that the law is obeyed. So I'm a little...
Madam Chair.
I can understand from a practical standpoint while the police would say, make it clear so that no one is in any doubt when a curfew order is a condition of bail. And under this new law, the curfew order can only be made by a deciding official who is a court or a judge. It's not the police or the JP that would make this order. I'd like to hear the views of members. Yes, Member
Madam
Campbell
Chair,
Rodriguez.
can I ask that we, before coming to a decision on this particular one, do a little research? Because the point you made about whether it's the approach or the fact that the police should not go, can we just have that verified? Because it makes a difference. If what the judge's ruling was saying is that the approach was wrong versus it shouldn't happen.
Not that the judge has said it's the approach. I recall, no, what the police said is that in some circumstances, when they go to the residence to check whether the defendant is complying with the curfew order, persons at the homes view their presence as a harassment.
But here in this thing, it is saying that some judges direct that this practice of checking must cease. That's what is there. And as such, if that is so, you see where it is, Madam
Yes.
Chair? As a result, some judges direct that this practice must cease as it is illegal and borders on harassment. So if a judge has said that, is it factual that that judges have actually said that?
I don't know. That's going to be a little difficult to check, but
Could we ask Mr. Daly?
Hold on. We could ask. My recollection is that is what was reported to him. But I do know that judges can make comments and do make comments from time to time, depending on what is said to them in the presence when dealing with a particular defendant or a particular case. I myself have had the experience of family members and defendants saying to me when I sat as a judge that the manner in which the police carried out their duties was seen as harassment. But when you drill it down, it really isn't harassment. But in truth, there is place for adjustment because, citizens can be unnecessarily hostile and make the work difficult. Police can be unnecessarily zealous and evoke responses that are not situationally appropriate. And that is why training should enable someone to assess the context and the situation and then conduct his or herself accordingly. But I don't know if there is any harm in saying that where certain conditions are imposed, just for an avoidance of doubt, that the police are indeed entitled. We have to, I'm open to hearing. Mr. Foreman, you have a perspective on this?
Yes. Chairman, if the recommendation is to give the police this authority, I'm not sure why the legislation would need to do that. Strikes me that the police have that power already, and that
right.
the issues that arise, as in the example that you gave, are in circumstances where the way in which the police went about exercising the power that they do have was in a way that was unreasonable. So that complaint is a fact-specific complaint, not one that goes to them not having the power to do so.
Which legislation provides that power?
Well, the police generally have the
both at common
the
law
power to-
and when you look at the Constabulary Force Act, is it Section 11 to watch by day and by night?
Right.
That provision.
Right.
Yes.
It's the police general power to enforce the law. In a circumstance
It's within
where
the general power of the police to enforce the law.
Right.
And the Constabulary Force Act, actually, the provision which says that they are to watch by day and by night, etc., is quite wide. And the common law also in the guidance provided.
Right.
Yeah?
And to the extent that in a situation where specific bail conditions have been imposed, checking to ensure that those conditions are being complied with would be an exercise of the police power to enforce the law. So as I've said, I don't understand if the comment is saying that they don't have the power right now and that they should be given the power, that's fixing a problem that doesn't exist. If the comment is targeted at specific situations where powers have been exercised in an unreasonable way, that's something that you can't exactly fix that in law. That's something that the courts will supervise on a case-by-case basis.
What I am finding, thank you, Mr. Foreman. What I am finding, Member Campbell Rodriguez, is sometimes problems are escalated and framed as legal problems when they are not. And as lawmakers, we have to avoid that trap of misconstruing a legitimate concern as a legal problem. Because there are many issues. It doesn't mean that the remedy is one of making an amendment to the law. It's the how as opposed to the what. And I think nothing short of just educating the public and also everyone minding their manners in their respective sphere will take us further along the journey. Because a lot of things is that what I find is there is such an anti-establishment, anti-authority realm where some people feel that no one in authority should say anything to them, perhaps because of the challenges that we have in homes where they are not exposed properly to the exercise of power by authority figures. So there is a huge gap in how they relate, or an absence of relating to figures of authority. All right. The other point about the inclusion of the Form CR 14 is one that I think we should consider. Madam CPC, you have any comment in this respect? It need not be provided for in the way that it is, but since we are also ensuring that the records, so if this is a standard form, may I invite a comment or response from you, Madam CPC, in respect of the inclusion?
I don't have a view on the inclusion or lack thereof. It's a policy decision.
Very well.
One would also should probably consider whether it might be more appropriate for regulations or for the act itself.
All right. So we would accept the recommendation.
Chair, before you say that, this is something that has to do with what happens during court proceedings.
Sorry?
Where they're saying that the clerk or the Crown Counsel is not taking into account what they have placed on the form. It's what happens while a matter is being heard in the court. It's not a matter that affects the Bail Act. It doesn't say the Bail Act excludes something, should include. It's not. They have their reasons why bail should not be granted. The issue they're raising is they don't feel that those reasons are being put before the court in the way they think it should.
So it's
That's not a matter for the Bail Act, with respect.
Understood, Miss. What I think it is saying, though, if we look at it a little more widely, is that when a person is arrested or detained, procedurally forms are filled in. And those forms have important record at the time. And in considering whether a person should be deprived of their liberty or should be released, then what is contained in those provisions should be taken into account. And standardly, if this is part of the procedure, then they should be made available. We must consider whether, as you have said, this is a matter for, if it's simply a question of the form being filled out and the matters contained not being taken into account, then the remedy is not to mandate it in the Bail Act, but it's a communication between police and the prosecutor.
So this may be something to discuss with the DPP's office.
Right. So again, we have to take great care in properly understanding the problem in order to ensure that the solution is a proper solution to address the problem. Mr. Foreman, you want to weigh in?
Might I also add, Chairman, I'm not sure how this proposal interacts with Clause 10 of the bill, which seeks to require decisions be reduced in writing and given to the various parties involved in the matter. And so where a deciding official grants or refuses bail, etc., that deciding official in a prescribed form is required to make a record of the decision and cause a copy of the record to be given to the defendant and the prosecution, as the case may be. I'd imagine that if such a document is in the proceedings, the various parties will rely on it as they deem fit. So that may also help to address the problem that Mr. Daly identified. But I agree that the description here is one that goes more to underground happenings than a deficiency in law.
So I think, I think the police seem to or need some further guidance on how they communicate the substantive matters that they have for consideration of the deciding official. So this provision could almost equate to one saying, I made notes in my notebook, you need to include my notebook because that's where I've put it down. So the form in which you have made the note may not necessarily be as important, not to say it may not have any value, as ensuring that the information is properly conveyed and considered. So it does seem like that is a different kind of a problem. So we appreciate the concern raised, but we could say that we are of the view that this is a matter that needs to be addressed between police and the prosecution, whether the clerks and the office of the DPP. Unless and until the clerks are all under the DPP, we would state it as a matter for the office of the DPP and the police. Right. So just to say that for any recommendation that we consider to be of merit, but not one for which is to be addressed in the Bail Act, I'm going to ask Ms. Wilkins that we ensure that those matters are communicated to the respective authority. Because this whole process is enabling us to ensure that related problems are addressed in the right place. So the recommendation, therefore, would be rejected for inclusion, is what I'm sensing, by way of consensus, and that we would recommend that they be addressed between police and prosecutor. The same for it. We would then communicate to the police officer that checking to ensure that a condition of bail is complied with is within their powers. And if the concern is about how they check, then that would be a matter for them to address in the approach taken, and not so much a matter that requires any additional provision in law.
The next is from Kishore Belani. In Jamaica, far too much crime is committed by so-called under 18-year-old children, and therefore my suggestion is that those 15 years and over, but under 18, should be considered young adults and treated differently than children under 15 years. When a 16-year-old is considered old enough to give consent to have sex, then why should an 18-year-old be considered a child when a crime is committed? When the law charges parents for negligence, the same should obtain where someone is held responsible for the action of an insane person, as the government should have proper facilities to house those people to keep them off the street. A lot of crime is also committed by insane people, and someone should be held responsible for it, and the matter should be dealt with so affected persons can get justice. A repeat offender or offenders should never be granted bail. Persons committing a crime using a gun should never be granted bail, even if that act was committed in self-defense and that person is a known criminal. They should never be granted bail. History shows that they are the ones who commit most of the crimes. It's like they will get bail today, and by next day, or even in some cases the very same day, they are back on the roads committing crime. Until the law allows for sentences to run at the same time for different crimes committed by one person, this culture is not going to stop. What I am trying to say is that a person who committed 2 or 3 different crimes must serve sentences for each crime differently.
A lot of things being said in that, but just to address the first part of the concern is that Jamaica adopted a standard definition of child in keeping with international instruments to be a person under the age of 18, and we abolish the distinctions legally that we had in the Juveniles Act when we passed the Child Care and Protection Act and repealed the Juveniles Act. But as a matter of practice, the courts do treat a little differently children depending on the stage. So, for example, you have child of tender years up to, I think, 7, 8. We have a mark of 12 or 14 for the legal responsibility. But generally, the approach in the jurisdiction where the age of majority is set as 18 to treat anyone under that age as a minor. And we have different treatments for different purpose. I think Mr. Belani just needs to understand that. I hear his concern. But it has to do with where the age of majority is set and an agreement in the community of nations to standardize the definition of a child as a person under the age of majority. And that age is almost commonly set at 18 years. In respect of persons insane, just to say that our own constitution provides for dealing with persons who are unfit to plead to criminal charges, and also people who are I'm looking for the provision. In the case of a person who has not attained the age of 18 years for the purpose of his care and protection. That is an explicit provision in the Constitution where such a person may be deprived of their liberty. In the case where they have not attained the age of 18 years for the purpose of their care and protection. I do not think there is any recommendation here.
No,
Mr. Foreman?
I don't think any of these relate to bail itself.
Yes,
They're
nothing
appear
relates to bail.
Broader matters of criminal law and
Right.
procedure.
But just to say to Mr. Kishore Belani, Mr. or Miss who is listening, we do appreciate your taking the time to write and share your views. It's just that for this law, it's dealing with a particular subject matter, and not every problem that exists in the society or in the justice system can be addressed in this particular piece of legislation. But thank you for taking the time to make a submission.
Chair, let me apologies to Mr. Belani. The third point that he raises is actually related to bail. So he recommends the recommendation to bar repeat offenders from being granted bail. Of course, the legislation now provides that this can be a basis to deny bail.
Well, Mr. All those offenses, bail, well, no, which a bail can be granted by a judge.
Right. Yes, thank you, Mr. Foreman.
Right. So there are factors to be these are all factors that the legislation acknowledges can be considered in terms of bail in the pre-conviction context. It would not be the bill does not, and we would not support a bar on bail in those circumstances, but that's not the policy.
Thank you. Here is how I would put it, is that both common and statute law recognize that where there are grounds for believing that a person, if released on bail, would commit an offense, that is proper grounds for keeping the person in custody. Common law, as in the law made by the judges, and statute law recognize that. So already the concept of bail in practice and procedure and in law takes into account that a person who is likely to commit an offense if released on bail, that such a person can properly be denied bail. And it is a matter that is taken into account. All right? But for the purpose of incorporating the recommendations in the bill, these recommendations are not accepted for incorporation in the bill.
Okay. Mr. Tony Lewis, the following are being proposed. 1. From a layman's perspective, my concern about this act is that it does not address any remedies for police officers who knowingly breach the requirements of the act. I say this to say that there are and will be many defendants who are taken in custody, not charged within the stated timeline, and are left to suffer in jail for extended periods. Most defendants don't know the law and their rights under the law, so they end up being victims of their own ignorance. Yet those who know better, most times, don't do the right thing. I don't think such behavior should go unpunished. My second concern is that bail itself is a punishment for most people. There are no clear options for a poor defendant who is given a minimum bail, but who just can't afford the minimum bail money. Everyone in the system may even agree that the individual does not belong in jail, but agree that their hands are tied in getting him or her released. No one should be held over in jail because of his or her lack of ability to pay bail. Let's just assume everyone is innocent until proven guilty, unless there are undisputed evidence of guilt. That is Mr. Leroy's comments.
I have to say that not only from submissions made and comments in this Joint Select Committee, but I have been pondering a lot about the impunity with which officials sometimes operate by not acting in accordance with the law or with the rules of engagement. It's something that bothers me greatly. It bothers me greatly. And while we have responded early that it is where there is little or no disagreement that errant officials should be held to account, the truth is that it does not happen timelessly or frequently enough. And there is a lot of grievance in the society around this. And I do feel very strongly that where the law sets a standard for conduct, whether it's how you discharge functions and powers, then that standard should be met. I feel very, very strongly that those who discharge the functions of state should be called upon to behave at a higher level. I think there is too much impunity in the system. I really feel, I have always felt very strongly about it.
Utterances, Chair, and at all levels who serve the public.
And I think it is why we will have to look very seriously in our constitutional reform work on the provisions for the public service. So when I say in another context about the review of the Constitution, and I'm being asked to provide details which I can't now provide. No. I'm just using it as an example. Don't get defensive about it. I'm just using it as an example. No. Because the real question is whether we should reconsider providing for something here. You know, the truth is that they are supposed to be properly provided for in staff orders and orders of the force, and we have to find a way of ensuring that superior officers carry out their duties. But so this law now, you see, they're saying that they are not defendants who are taken into custody, not charged within stated time, are left to suffer in custody. So when we were looking at the pre-charge bail, this is one of the considerations that we took into account. The number of cases where the allegation has been made of people languishing in custody. And then we get a response, oh, you can't do it, it's unconstitutional. And I'm saying, but this provision is designed to restrict the liberty as least as possible, even in circumstances where the law provides that the liberty can be taken away. Mr. Foreman, you wanted to weigh in?
My only comment would be that this is not a problem that's limited to the Bail Act or to the police. As you have indicated, this type of concern goes more so to a broader systemic type issue. And in terms of what's already there, whatever provisions exist for disciplinary action to be taken against individuals where a proper complaint is made and so on, that possibility already exists. And to go back to the specifics here, where there's an allegation that a person has spent more time in custody than they should have, or something has not been done, those typically, I would think, are matters that would have to be fleshed out in some type of hearing process, so that in any event, whatever actions are going to be taken might be something that arises after some type of judicial proceeding has taken place, and on facts that have been established, it emerges that someone has acted well outside of the bounds of what they're supposed to do. So I would be wary of attempting to insert here a fix to this problem.
Chair, I believe the Judicature Parish Court Act places a responsibility on the part of the parish court judge to conduct a check periodically to identify persons who have not been brought before them.
It's in this law too.
Yes, but yes. I think there's more there. But I also recall when the Legal Reform Department was a part of the Ministry of Justice, that Minister Chuck had considered his policy direction was for having JPs involved in supporting the judge's responsibility in that regard. I'm not sure how far it has gone, but I do recall that that's a matter that comes up from time to time, and that was one of the measures that were being looked at. But it is indeed an issue. There's no getting around it. And a lot of times the police have reasons too why they weren't able to. So it's not always because the police were being derelict or vindictive. There were sometimes very practical reasons why they were not able to do what they should have. So I don't think we should look at it in this law. I think it should remain something that administrative measures be looked at, or non-legislative solutions be looked at.
Remind me of the clause here where we places a duty on the parish judge to do the remand check and on the relevant persons for the lockups and station and jails to supply the list. So just to say to Mr. Luars that this problem of ensuring that persons are not languishing in custody is a central feature of this law. Through the pre-charge provision and also incorporating the duty on the judge to make the inquiries.
He can help us out, 'cause we're looking for it, but perhaps CPC could help.
Is it 11? Right, just to say that at clause 11.3, we have expressly placed a duty on the court.
It's a little different.
It's a little different,
Yeah,
but
the
it's also to
responsibility in the
ensure.
Judicature Act
Right.
is for the judge to go to the jail.
Yes, I used to do it,
And
Miss
right.
Wilkins. We
Yes.
used to call it remand, checking
Yes.
remand.
Yes, so
And I can tell you some real stories about what I learned from doing it.
I can
Real
well
stories.
imagine.
But in addition to that, I think that addressing the issue legislatively is covered as best as it can be covered.
Yes,
and
in
any
that
other
act.
gap would have to be filled administratively.
You're right. And it,
Right?
yes.
So the recommendation
And
is
it would
not
continue
accepted.
to be a matter for that
Yes.
act, I think.
All right, we're coming up. We're at 1 o'clock, a little after 1. Persons may need a little lunch break. It is my hope that Member Jackson will be staying for the full duration of the committee. Until about 4. We probably need to go a little faster because we do have the pre-charge bail regime where we'll have to spend some. We can take a decision to do a short break for persons who are present in the chambers to be refreshed. We could do a half-hour break. I don't want to intrude on matters of welfare. Or we could go up to 2:30. I am not able to hear you, Miss Wilkins. I do not think the mumblings are meant for my ears. But, I mean, this is an inquiry of welfare. I know persons who are present virtually have greater flexibility in refreshing themselves than those who are present in chamber. Member Paulwell, you are saying that you... Member Paulwell?
Yes, Chairman. Yes, unfortunately, I have some constituency matters to attend to, so I won't be able to rejoin later. But I'm following very, very diligently And it's the next subject matter that you are about to move to that I am most interested in, but I will get the notes.
Right. I just want to ensure that all members are present for consideration of the recommendations in respect of those matters.
Yes, and I see my colleague, Senator Scott Motley, is also having a problem in remaining for the rest of the early afternoon.
You know, that's going to pose a problem for us because it's going to impact the quorum and also...
Chair, there was nothing that communicated that it was an all-day meeting, respectfully. And I thought we were going up to 1.
Yes, that was my thinking as well.
My recollection is otherwise because we're not sitting tomorrow. That was my recollection. We hadn't sat on... We didn't, yes, but you do not recall. Yes, it was my recollection that was indicated. I know many things compete for time, but I understand and appreciate that. But let me just pause for a moment to just look administratively. You see, what I'm trying to avoid is a situation when we come to the report for what is accepted and rejected without a participation in the process. It's really not what I'm trying to avoid that situation and to ensure that, you know, when we proceed with a clear understanding of what we have accepted and what we have not accepted or what we have divergent views on that require further thinking through. And that approach will be impacted if members, particularly the members from the opposition, are not present for that part of the deliberation. Let me just pause to look at our next date. All right, I'm going to suggest that can members who need to depart early stay until 2:30 and we take the break then? I'm sorry?
No, I have to leave now. In fact, I'm rushing out my office now.
And I unfortunately, I agreed to a commitment which starts at 1:25.
We have members Chuck, Williams, Charles, Sinclair on. All right. I guess I really can't do anything about those who have to leave, but we would like to consider further matters. Just to say for those who are leaving that the next meeting will be next Wednesday. And I'm going to suggest that you set aside the day for that meeting, even though it may go for less, but just set aside the day for us to go through.
Next Wednesday.
All right? I'm also going to suggest we take, I think you want a little break? No? Want us to just go through? All right, we will then go through up to 2:30, around 2:30, 2:45 for today. We noted the departure of Member Jackson at 1:14, Member Paulwell, and I see Member Scott Motley is still on. But just indicate.
I was typing and asking to be excused, Madam Chair.
Very, very well. So
I'm on obligation at 1:25, and I don't get up to refresh myself when I'm in joint select, so
right.
I would like to leave now.
Very well, Member Scott Motley. So we will
Thank you, Madam Chair.
The departure of the opposition members, 1:15, all right? And where we are at this stage. All right, please proceed.
So the other recommendation was for the provision that would result in the incarceration of a person who is unable to provide surety or the bail money. They wanted that to be removed.
That is not in keeping with the policy.
So that's not accepted.
Which part of the recommendation you're speaking
The second one, that was said that they didn't think it was that a person who is unable to provide bail money should be incarcerated for that reason. So bail will have been granted, but they can't take it up. They don't think the person should be locked up.
That would be really a matter for the deciding
judge.
Official
Yeah.
in the exercise of their discretion, since bail can be granted conditionally or unconditionally. Or generally it's on condition, but it would have to decide how do you secure the attendance, the submission of the person
regard to the
custody, having
circumstances.
regard to the circumstances. And for that reason, I would say that the recommendation would not be accepted.
Okay.
Right.
Okay, so we move to the other
Oh,
document.
Madam Chair, sorry, before you move on.
Yes, sorry, Madam CPC, I missed your hand.
Right.
Yes.
I just wanted to draw attention to the fact that there was, in fact, a special provision in 11.3, clause 11.3, pertaining to defendants who are granted bail but were unable to take up bail. And there's a provision for review of their cases every 2 weeks by the judge, who is empowered to
Yes.
make such other orders as the court might consider appropriate in the circumstances.
Thank you, Madam CPC. So the concern is actually covered in the provisions at 11.3. Thank you.
So we go now to the larger document.
It really means that it's not accepted because
Yes.
the issue is already
Already
covered
resolved.
in what is
Okay.
provided for at 3.
The
All right,
Jamaica
you want to
Bar-
look on page 4, the smaller matrix. From Mr. Jarrett. I see. Very well.
So the Jamaica Bar Association recommendations. At present, the law provides an avenue for the prosecution to oppose an application for bail if it can prove that the accused would likely commit an offense while on bail. This is but one of the many bases upon which the prosecution can oppose bail. If the prosecution has put forward such evidence and is dissatisfied with the court's grant of bail, the prosecution has the right to appeal that decision. Given the lack of bail appeals by the prosecution, the government should seek the existing, I guess I meant to examine the existing bail regime by A, improving the adequacy and quality of evidence given by the police to the prosecution to support the prosecution's opposition to the bail, and B, providing the Office of the Director of Public Prosecutions with any additional resources that her office requires to pursue bail appeals that are considered necessary in the interest of justice and public safety. They're very general, yeah.
So, from what I'm seeing, these are not matters for the Bail Act, for recommendations for the Bail Act. I think the bar generally would know that the thinking in the courts is that a bail hearing has to be treated a little more formally than what has existed in the past, because merely saying I object to bail is not going to cut it for a denial of bail. And I think the system is moving in that direction already, where substantive material has to be presented to the court at the time when the question of bail is being determined. So the recommendation of improving the DPP's office is not accepted for the purpose of the Bail Act. But just to say that much improvement in the resources of the overall justice system has taken place within the last 6 years, and increase in the number of Crown prosecutors has also taken place, both in the chambers on the civil side and also in the DPP's office on the criminal side. Right? And we have even had increase in the number of judges too over time at all levels, including in the Court of Appeal, where a whole new panel can now be assembled to sit. Right?
Not quite sure how to pronounce the name, but Camille Golding.
Yes?
It is also suggested that the definition of surrendering into custody and bail in criminal proceedings from the Bail Act 2000 be carried over into the Bail Act 2022. Further, though Section 3 stipulates that the Act applies to the grant of bail to a defendant, because the term defendant is also used in civil proceedings, for young persons just learning the law, it is suggested that it is important to them to understand that bail only exists in criminal proceedings through the exposition of the term in the interpretation section.
I think that first recommendation would have already been considered and discussed when we're looking at the recommendation about a definition of bail. Would you say? Pretty much?
Well, the bill does define surrender to custody. So
the second part, bail in criminal proceeding.
Okay.
Yes.
But the term isn't used in the bill. So if the term isn't used in the bill, then I guess, whereas in the existing act, the term is used.
Right.
Faculty of Law.
Not accepted.
In relation to discretion, the bill, across its provisions, seeks to place fetters on the judicial factors to be taken into account in the grant of bail. While the Privy Council in Charles has indicated that the imposition of conditions in the court's exercise of its discretion in granting bail may suggest survival to a constitutional challenge, care must be taken to ensure that the discretion left to the court is real and not illusory. The imposition of stringent conditions which render the remaining discretion to the court extraordinarily narrow may lead to an unconditional outcome. So I assume I don't know. Yes, I'm not sure. Where has the discretion been?
I don't think, well, my view is that there is a difference between providing guidance to the court on the matters to be taken into account and fettering the jurisdiction. And I think there seemed to be a little misunderstanding you see, what I wonder is emerging is a different kind of understanding about the use of terms, the may and the shall, and the exercise of discretion. The courts, in reported matters and comments and commentaries, have asked for better guidance, stipulation of matters for their consideration. What we are seeking to do is to aid the court by placing specific matters for their consideration, and they are placed in such a way that they are considered on both sides of the justice equation. So a single matter, when considered, can inure to the benefit of the defendant as well as the prosecution. And I think that is how they are placed. So conduct of the defendant, for example, to be taken into account. When the conduct is assessed, it can say this defendant has conducted himself in such a way that they should be released. Or this defendant has conducted in such a way that shows he's likely to be a flight risk. He's likely to, obstruct the course of justice, etc. So the matters are not put, to my mind, I don't know if anybody else has another view, in a way that would amount to a fetter, but properly helping to guide the exercise of discretion. Mr. Foreman?
Right. Chair, I'd only like to add that if the comments are in relation to the factors that may be considered by the deciding official in refusing to grant bail, the language used in Clause 7.1, for example, and the language used in the existing legislation at, for example, Section 4.1, is actually the same. Right? So it is bail may be denied to the defendant in the following circumstances, and then it lists the circumstances. And the bail uses a similar formulation. Bail may be denied to the defendant in any of the following circumstances. So insofar as...
It does appear that something is happening with our camera online. Oh, I see.
Right. So, if the existing legislation is understood as being discretionary, the legislature indicating its view as to what sorts of considerations ought to be borne in mind, then the same interpretation would logically have to be placed on this bill if it becomes law in the same exact terms.
Right. So I hear you saying that since the current bail law and the bill makes a provision similarly, and there is an understanding that it is discretionary, then the concern is not as valid as it would appear. All right. Thank you.
Okay.
Not accepted.
The Jamaica Constabulary Force Legal Affairs Division. We are grateful for the acceptance of our recommendation as to the inclusion of pre-charge bail in the bill. However, there is no mention of what happens when a person on pre-charge bail fails to adhere to the conditions of said bail. We reiterate our recommendation that breach of a pre-charge bail condition should be made an offense in the bill. The term vary as defined...
Just let's pause to get a response. Yes.
Okay.
No, I was going to recommend that that's a matter that deals with a specific clause in the bill, so that when we get to that, it may be more convenient to address it there. Right. So I would, right, yeah, I wouldn't categorize it as a general recommendation as such.
The second general recommendation may be deemed the same because it's dealing with a recommendation for a definition. So that would be clause 2. They're recommending that the term vary, as defined in the interpretation clause of the current bail legislation, ought to be maintained for clarity and wholeness. The bill provides at clause 9.2 for the variation of bail in certain circumstances, but the bill does not contain a definition of vary. We propose that the following definition for the term vary, which partially retains the definition contained in the current act. Vary in relation to bail means imposing further conditions after bail is granted or changing conditions imposed in relation to the grant of bail. I'm not sure if you want to take that.
Invite a comment from the CPC or a response.
Madam Chair, looking at the definition that was provided for vary, that doesn't really add anything to what it would normally be understood by the term. So I'm not sure what the purpose of including that definition was.
All right, that reminds me, Madam Committee Clerk, when we are putting the report together, please indicate the reason why we do not accept the recommendation, just for completeness. Not merely to say that a recommendation has not been accepted, but the reason given in our consideration of the recommendation. All right. So in this case, that adding the definition would not add. What's your reason, Madam CPC?
Yeah.
The definition in the existing act is not different from what would be the ordinary meaning of the term vary.
Okay.
So in my view, there's no need for a definition of the term vary. And in fact, it is a little, I suppose.
Is there anything adverse that could happen by not defining?
Very well, thank you. So the recommendation is not accepted for that reason. Okay, thank you. Next. And just to say for those listening on, if the ordinary grammatical meaning of the word is what matters, then providing for a definition that doesn't change it really adds nothing to it and may unnecessarily complicate matters. You usually define when you want to provide for a technical meaning of a term or expand upon the ordinarily understood meaning of a word. Right, next.
We note that whilst the Act creates an offense in the instance where a surety makes a false statement, there is no similar offense where a defendant makes a false statement when being granted both pre-charge and post-charge bail. As we have seen this practice of defendants, we recommend that an offense be created where the defendant makes a false statement about his name, age, occupation, address, place of work, place of residence, etc.
A note that the recommendation is specific to the identity of the person. And I think that identity of a defendant is critical in any case, because the question is not whether an offense has been committed generally, but whether the person detained or arrested or charged is the person who has committed the offense. I have an appreciation of the recommendation that is made. But yes.
But is there a duty? Is there a duty on a person's part now to truthfully answer the police?
Well, it's not just so much a prejudicial effect, Miss Wilkins. It's also of probative value. And I would like to think that persons who are being brought in and engaged in the criminal justice system, sometimes we think about the provision of information in a prejudicial way and probably think that I'm under no duty to speak truthfully. But I certainly see the value upfront if identity may be in issue. A person providing truthful and correct information may assist. I'm not saying that's the be-all or end-all of the determination of the matter. I'm just saying that where I look on the issue, I do not look at it only from a prejudicial effect perspective, but also persons being questioned by the authority should speak truthfully. Whether we make that an offense is another matter. But I appreciate it, because if you're giving wrong information with a view to misleading the police or to obstructing the course of justice, then that the justice system recognizes that as egregious and offensive in law. Or, yes.
Yes, but that's a matter that
Mr. Foreman, let me hear you weigh in on this.
it's a matter for the proceedings afterwards. Once it is revealed that the information you provided was incorrect, whatever inference is to be drawn from that and whatever disadvantage to your case resulting from that is something that you have to deal with. But it's for the court to be told all those things and to make its own determination of how to deal with it. But I think we would be delving into...
So in the ZOSO law, we do have a provision for the places a duty to give name and identify yourself,
Yes, does it place a duty that the information you provide must be correct? That's what this is saying.
Look at it and see.
It's not so much that you must provide the information. The question is it an offense to not provide the correct information?
In many cases, the law is replete with examples where providing false information is an offense. We have many examples in the jurisdiction where that is so, Ms. Wilkins. You would know that. I'm sorry? You have a right against self-incrimination, but provision of the information is not just about incriminating you, it's also about exculpating you.
I'm just saying that there are issues here that are to be balanced.
I'm going to ask for a deeper consideration of it. Mr. Foreman, I'll ask you to assist us.
I think that's a
Let's
good idea.
defer this recommendation for some further consideration and research. All right, proceed.
The Norman Manley Law School, it is submitted that the overall extension of time limits throughout the proposed act for keeping persons in custody, even when cleverly broken down into different tranches, work on fairness, I think we have some words missing here, to the subject. The impact of these time impositions is not only to increase the periods of time an innocent person spends in custody, but also to suspend the usage of habeas corpus. Altogether, and when added to the other infringements in the bill, these provisions are likely to be unjustifiable under the Constitution. Is that the only one?
I've been trying to... I'm going to make a general comment. Members of the public place great reliance on the authority when statements are made. So depending on the level of eminence attached to someone, importance is going to be placed on statements made, whether those statements are correct or incorrect. I can't help but express my own disappointment in some of the submissions that came, including some of them that came from the Norman Manley Law School. and this is not saying that you must agree with everything or anything, but it's the level of analysis that I would expect to come with the matters, which for the most part I found to be missing. So the law is not speaking about extending time for keeping people in custody. It is saying that you don't keep them in custody. And it sets specific time limit. Let me open it for comments by others. Yes, Mr. Foreman.
Sorry, Chair, to the extent that there are specific provisions in the bill with time periods in there, it might be better to consider it so that you can look at it in context.
Yes.
The specific
so we have time limits in respect of the 48 hours. For the 48 hours, we have time limit in respect of how long you can keep someone on pre-charge bail, and what must happen afterwards. We have the court, the invoking the jurisdiction of the court to monitor how long the person is kept in custody, because that is not a matter that is determined out of court, even in a pre-charge context. And I don't know who is better placed to determine, having assessed all of what needs to be assessed, what would be fair in the interest of justice and in the interest of the particular defendant. And that's why I wonder if the concern is about the time period. It's one thing, but the general way in which some of the comments and recommendations were cast left me to wonder whether there was a proper reading of the proposals. So I think your suggestion for us to consider where time is prescribed, the greater concern raised is a good suggestion. But it doesn't take away from my own view about the lack of a nuanced approach that one would reasonably expect coming from a representative of the institution. Yes.
It is submitted that the bill is likely to be found in violation of inter alia sections 13 and 14 of the Charter of Fundamental Rights and Freedoms as an unlawful encroachment because the provisions in question cannot be shown to be demonstrably justified in a free and democratic society. Is legal aid to be made available to a person who has not...
What page are you reading from?
This is page 2, continuing the general recommendations from Norman Manley Law School. It continues over. Sorry.
So let me just use this as an example of my own expectation from the law school. So we know the standard of derogation that is set at Section 13 of the Constitution, demonstrably justified in a free and democratic society. And we know from numerous cases, including the Julian Robinson and the Attorney General, the Jamaican Bar Association and the Attorney General, and other cases which adopt the Oakes test as to the approach that should be taken and the kind of analysis, limb by limb, that should be done. I do not think that it is unreasonable for me to expect that kind of analysis from the law school if it is invoking that ground as a basis for objecting or frowning upon a provision. I mean, I just have to say that from where I'm sitting, it's entirely reasonable for me to expect that if you are analyzing a provision as to whether that provision would meet the standard of derogation as provided for and as pronounced upon by the court, that you should come with the analysis starting with the justificatory criterion, looking on the test of proportionality, looking on the design of the scheme, etc., all of the guidance that is provided for. I think it does an injustice to make broad statements, and especially for those who are not learned in the law, who will swallow hook, line, and sinker what is said, when you fall short of doing the work at the depth that is required. Continue.
I think it's an extension of that first point that was made, read the time periods. None of them, I think it should be, because it's speaking of, because the provisions in question. So I'm thinking they must have meant it to be, to continue.
Not my recollection. It's just the entire concept of the pre-charge bail.
Okay. All right. So we go on then. Is legal aid to be made available to a person who has not been charged? It is noted that there has been no consequential amendment to the Legal Aid Act. In the bill, legal aid would be necessary for pre-charge defendants to have their rights respected, especially those in custody.
I can appreciate this question being raised, and at the end of the day, it will require numerous related consideration. So there is a provision which says that every person charged with a criminal offense shall be entitled to defend himself in person or through legal representation of his own choosing, or if he has not sufficient means to pay for legal representation, to be given such assistance as is required in the interest of justice. And
who is charged?
Hold on.
Okay.
Naturally flow. So the question is whether we construe it narrowly or we construe it a little more widely. There are different rights that flow. So the right to bail, the entitlement to bail, is not a right that is flowing from a charge, but from a deprivation of liberty. So we have to analyze it a little more. So when we read purposively, the question was posed as to whether in our Constitution a person not charged with an offense could be granted bail in looking at the pre-charge bail regime. And our response was that we are looking at it at a higher level of a person who is deprived of their liberty on reasonable suspicion of having committed an offense. And if the Constitution says such a person can be taken into custody, and you're to either release them conditionally or unconditionally so that they can return at a later stage to stand trial or any other stage of the proceedings, then what do we do with such a person? So the question is, for the legal aid provision, where do we keep it at the person charged, and for what reason? Mr. Foreman, Ms. Grant? Yes.
He's checking something.
Thanks. Yes, Madam Chair, but the Section 15 of the Legal Aid Act already provides for legal aid to be granted to any person who is detained at a police station or a lockup correctional institution or other place. That's A and B to an accused in respect of, well, that relates to plea negotiation. So legal aid already applies where you have been detained at a police station, lockup, or correctional institution or other similar place. So I don't see the need for any further provision here.
Thank you, Madam CPC.
Yeah, that's a complete answer.
That is a complete answer. So when we put that we answer the question, we will answer the question by referencing that. But in effect, the Section 15 of the Legal Aid Act would be a reflection of a more purposive interpretation of the provision at 16.5. So we always have to be careful about the approach that we take in interpreting rights provision. And it doesn't mean, as the Privy Council has pointed out, that you are creating rights where they have not been created. But you generally take a more purposive approach and not a literalist one. But thank you, Madam CPC. Complete answer provided. And I suspect that it begs the question whether it would have been unreasonable for the law school to have done the research, since the law school also has a legal aid clinic.
I think it's a situation where generally it is contemplated that this person has been charged to be in operationally. I think that is perhaps where they were focusing their minds. But legislatively, provision has in fact been made for it, whether or not you are charged. So, yeah.
You know, Ms. Wilkinson, that sometimes people create a legal problem when it's really an administrative problem.
It could be an issue concerning the process for obtaining legal aid,
which is not a matter of a prohibition in law.
Yes.
And it also could be genuinely a matter of available resources. Yes. But the truth is that in this jurisdiction, there are standards for the treatment of persons who have been deprived of their liberty. And we have come a long way from where we were years ago in ensuring that persons are treated better and properly in keeping with their dignity as a human being.
There are a number of provisions conferring jurisdiction solely on the court, stroke judge, who has jurisdiction to try the matter. For example, A, Section 11(1)(I), dealing with reviews. B, Section 11(3), judge reviewing of defendants in custody. C, Section 18(2), dealing with release of surety. D, Section 17(1), dealing with forfeiture of recognizance. E, Section 8(5)(a), surrender of travel documents. These provisions are problematic because most criminal matters begin their life in the parish courts, and in particular, matters that are to be tried in a circuit court must spend considerable time at this level before they are committed to circuit. It should be noted that the majority of the divisions of the circuit court do not sit continuously, only once per term. There are in fact only 3 continuous circuits: Home Circuit, St. Catherine, and Clarendon. Therefore, defendants and sureties from the once-a-term sitting parishes will have an onerous and unnecessary hurdle in accessing courts on the relevant issues. Furthermore, the judges of the circuit would also not always be available to carry out the reviews under Section 11(3)(a). This restriction on jurisdiction would also impact the parish court judge, who has a jurisdiction to hear Committal Proceedings Act, and who has powers granted under Section 41 of the Justice of the Peace Jurisdiction Act to grant bail at the conclusion of criminal proceedings, of committal proceedings. This is 11. But it's specific to 11, though.
So when we took the decision to give the court with a jurisdiction to try the matter, jurisdiction to deal with the issues, it was really with a view to ensuring that the matters could be more conveniently dealt with. So the question, it is not the intention to make it more problematic for those defendants who need to have these matters properly dealt with, to have a higher bar to cross. Madam CPC, may
I don't know if it's a problem for
hear your thinking on this?
Jeffrey. Oh, Lord.
Madam Chair, My view was similar to what you just expressed, that it would, my thoughts would have been that it would have been more convenient for that court to hear the issue. But
Is there a way that we could make an alternative for the parish court to deal with it without creating any bit of problem? Because the intention really was to be facilitative. I know we have to be careful about who has jurisdiction for a matter at a particular stage of the matter. And jurisdiction is not normally given to a lower court where the matter is properly before the High Court or the Court of Appeal, and those are accepted rules of practice. Maybe we could speak to the Office of the DPP to hear if they have any guidance that they could assist us with on this. So let's see, the review of the defendant in custody. Well, in respect of 11.3, I don't see how the point is exemplified by 11.3, because if the defendant is in custody, let's just consider a little more deeply. 11, the point is that
You're saying that a circuit court judge would not be someone able to comply with the requirement at 11.3, having regard. Because it's, I don't know.
But my understanding is that it is done at the gun court, for example, no. I don't know if they do review defendants who have been granted bail who have not taken it up. A judge of the court concerned shall at least once every 2 weeks carry out a review of cases involving defendants who were granted bail in relation to offenses to be tried before that court, but who were unable to take up. The concern is that if the court in question is, say, the St. Elizabeth Circuit Court for the parish of St. Elizabeth, it's not sitting continuously, who would be the judge in the 2-week period? Because the judges are assigned when the circuit time is set.
The existing law makes only provision for that in the parish court.
Only
yes.
At the parish court level?
Yes, it's at 12.2 of the existing act.
Just remind me of what it provides for.
A resident magistrate shall carry out at least once per week a review of cases involving defendants who were granted bail but were unable to take up such bail. That is.
But our intention was to extend it not just to matters within the jurisdiction of the parish court, but to all defendants at all levels of the court system who were granted bail and are unable to take it up. But I see the practical difficulty raised by how it is provided for, which may for practical purpose defeat what we're seeking to do. And so my question is, how else do we provide for it to ensure that for defendants who are before those circuit courts that are not sitting continuously are not at a disadvantage? And who would be the judge assigned to deal with it? It does raise a practical issue in terms of how it's provided for. All right, let us defer this one for further consideration. And Ms. Wilkins, may we invite some guidance from the Office of the DPP on this one? Or probably even the courts through the court administration, because the rostering of judges to deal with matters is, all right? So we would ask, let's just be clear now, do we write to the Chief Justice we'd ask the committee clerk to write to the Office of the Chief Justice to invite a comment on the clause from an administrative perspective against the concerns raised by the Norman Manley Law School on this point. Is everyone, the ones that are specified, 11.1.1, 11.3, 18.2, 17.1, is everyone in agreement with that suggestion? I can't see the nodding heads. Member Campbell, you're nodding your head, but I would like you to go on record with a response. You'd have to go with the mic so that the records can reflect.
I'm in agreement with the recommendation.
Member Chuck, Member Sinclair, Member Williams, Member
So
Chuck.
am I in agreement.
I think it makes sense because we thought we had solved a problem by giving the court with the jurisdiction.
Yeah, there you go.
Yes. Madam CPC. And I think it would be quite in order to invite such a comment from an administrative perspective. It's not so much. I'm sorry?
My expectation would be that the court administration.
Court administration,
would be,
yes.
Yeah. But I think it goes through the chief. Right.
Yes.
And then the Chief Justice will
Right.
assume direct
Yes.
through the relevant channels.
You can let me see the draft before we send it out, but we send it out as quickly as possible. All right, so we will defer this one for further consideration and also seek the comments of the DPP and the judiciary.
The Independent Jamaica Council for Human Rights. Oh, sorry, Chair.
Yes, proceed.
Madam Chair, are we finished with the recommendations from Norman Manley Law School?
This specific one? The general recommendation.
Oh, very well.
Okay. So, the Independent Jamaica Council for Human Rights. The bill now describes such a person as a defendant, basically synonymous with an accused, pitting the person against the state in an adversarial legal system that now has to be navigated after liberty has already been lost. But no charge has yet been laid for any offense, and it might be considered that such a person should instead be referred to in the bill as a suspect, in keeping with the time-honored nomenclature that automatically carries with it the above-mentioned safeguards. I don't know if you want to deal with that, Chair, or continue. Should I?
That's one.
You'll wait until you get to the clause?
Well, you know I don't think there's any secret on my view. And for the team that dealt with when we were dealing with the policy issue, it was my starting point that there is a proper term for each person at each stage, because pre-charge, the person is a suspect, and that's a term that is understood in the criminal justice system. When you have been charged, you're formally accused, and after you're convicted, you're a convict, and those terms are known. And that was my starting position, that we already had specific terms in the criminal justice system for the people who would be the subject matter of the regime. We had, it's interesting how, just to take the story from behind the curtains, that my team felt that using the term suspect was very prejudicial, as also using the term convict And now others are saying that using the term defendant in an umbrella way is more prejudicial than using suspect and convict. And then from a practical drafting perspective, the need for an umbrella term so that you do not have to repeat. I think a creative solution can be struck, but I'm going to leave that to
this was suggesting when we get to the interpretation provision, because the comment comes back up again from other.
Yes,
so
but it's something...
We could defer it until we get to clause 2.
Yes. So, I mean, without trespassing on the jurisdiction of the CPC, among the things that I wonder and will wonder aloud is, as the case may be, or as appropriate, the defendant would be the suspect in a pre-charge context, a convict in a post-conviction context, and an accused in the post-charge, pre-conviction sentence context. But I hear the unease of presenters and members, and I think we would have to spend a little time looking at it again. All right?
Okay, another recommendation from the IJCHR. The bill does not, at least not from the material available to the Council or the public, appear to have been conceived in an environment of empirical research to establish that the discretion of the judiciary has been so unreasonably or otherwise so detrimentally deployed that the judiciary deserved to be circumscribed in its jurisdiction over bail.
I find this to be an unfortunate comment. I really find it to be an unfortunate comment in the same way that I found other comments unfortunate. The constitutional role of the Parliament is to pass laws. And it is quite permissible for the Parliament to specify what matters need to be considered by the courts. And I think some comments seem to just be pitting the branches of government against each other unnecessarily so, without a sufficient appreciation for the respective roles of the different branches of government. Assisting the court by itemizing matters for consideration in the exercise of their discretion is time-honored, and nothing different is being done. We may be adding matters to ensure that something is not inadvertently overlooked. In the same way that the law says is not whether the judge is presumed to know the law, but is whether the judge at the time of considering a matter has the relevant principles in the forefront of his or her deliberation. So whereas, and this is in terms of summing up the guidance that the higher courts have provided. Yes, the court is presumed to know the law, but the court must demonstrate, a judge in particular, that at the time a particular principle of law is forefront in the deliberations and considerations and application. And it's a similar thing that is happening. But the rhetoric is so combative and distrustful, almost as if to suggest that when the legislature is doing its constitutional role, playing its constitutional role by passing laws for peace, order, and good government, it is intruding on the judicial branch. I really hope the time will come where statements will be more responsibly made and not add fuel to the fire of pitting the branches of government against each other in a context when sparks can so easily ignite. and burn the place down, figuratively and literally. Yes.
So we get to clause, the specific clauses now. Clause 2, Jamaica Bar Association. Definition of the term conviction. It is recommended that the definition of this term should have a connector at the end of subparagraph B. We recommend inserting the connector "and." The word conviction would therefore be interpreted as including all circumstances listed in subparagraphs A to C. I think that's a CPC issue.
Right. So in this case, the provision is termed as one that's inclusive. In this case, whether you include the word "and" or, it would be immaterial to the meaning of this provision. And in that case, drafters normally don't include an "and" or an "or." So no, what they're terming as a connector, it's not necessary. Because if you had read it with either "and" or, it would not have changed the meaning.
Duly guided, Madam CPC. Duly guided. Please state that the recommendation is rejected for the reason stated by the learned CPC.
Yeah, not accepted. Definition of the term deciding official. The following have been proposed. This term should expressly exclude the arresting and investigating officers and all police officers who have been involved in the investigation. Given their potential for bias, those officers should not make a decision on bail. In order to remain consistent...
Page 5?
No, yes. I'm just going through all the Jamaica Bar Association recommendations on clause 2.
Yes.
In order to remain consistent with clause 5.1a.2, the definition of deciding official should be expressly restricted to constables at or above the rank of superintendent. I think the bill does that already. Well, doesn't it say that?
So my understanding is that they would want only a police officer of a certain rank to be the deciding official when that deciding official is the police. It's a little different from what we have provided for in the pre-charge bail regime. The reason why we have placed it at that level is as to signal that it is not any and every defendant that would be taken in on pre-charge bail, but it would be those who are actually at the level, who have been brought to the attention of the police high command in the area. And also by excluding the arresting officer or an officer involved in the investigation, the officer becomes a judge, quote unquote, in his own cause, and that he or she would have to justify to a superior officer why this person has been taken into custody in accordance with the factors set out in the law.
I think this one is perhaps just drafting style, because the definition does say constable, as the case may require, who is the competent legal authority on the matter of the grant of bail. So it would take you to 5.1a.2, where it says a constable at or above the rank of superintendent.
It's a little different suggestion. So currently, you do not need a constable at the rank of or above superintendent of police to grant station bail. It may be granted by an inspector, even a constable, if a sergeant, a deputy or assistant superintendent. And that is for administrative ease. But right now, we're saying for those persons who are detained but are not immediately charged, and would fall under the pre-charge regime, we are placing the deciding official, the police deciding official, at a higher level to ensure, as part of the safeguard against abuse of an officer just pulling in someone and putting them on bail, or denying them bail and then having to take them before the court. It's a different point. So it's really a policy question that it raises as to whether a police who grants bail generally should be at or above the rank of superintendent. That would pose a problem for defendants, because we do not have superintendents at every police station, and it may delay. But in respect of the pre-charged persons, it's just to ensure that these people their alleged misconduct and criminality is being monitored at a higher level. It is deliberately not consistent. It's deliberately different.
Problem.
I'm sorry?
It presents a problem whenever you use the term deciding official. I'm just checking. Maybe that's why they were thinking that we should ensure that
Well, we'll have to look at it to ensure that there's no problem, but just to be clear about the policy behind it. The distinct difference is for a particular policy reason, that the constable who is empowered to grant bail pre-charge must be at a level of superintendent or above. Generally, I would say it makes good sense at any level that the constable who is granting bail is not the constable who is the arresting officer or an officer involved in the investigation. But I wouldn't want to create practical difficulties for that, for any specification. Member Sinclair, you practice in the criminal courts. Tell me, from your experience, you have police officers who are arresting officers or investigating officers granting station bail now?
Yes, Madam Chair. What you'll find is that the arresting officers, they will indicate to the custody officer that they have no objection to bail. The custody officer is normally someone at the rank of an inspector of police. So the arresting officer doesn't say that the person will be given bail. They just would indicate that they have no objection to bail, depending on the nature of the offense and the circumstances surrounding the particular case. They may give guidance, but they are not the persons who ultimately determine whether the person is given bail.
So the question that arises part of the question that arises is whether we should expressly state that the officer who is granting bail should not be the arresting officer or an officer involved in the investigation. I just want to, I see the logic. We already have that in the pre-charge bail regime. The question is whether we put it generally. And if you're saying that what obtains in practice is that it's another officer, not the arresting officer, the arresting or investigating officer would simply provide information as to their position in respect of the grant of bail, then we wouldn't create any problem by saying that where station bail is granted and the deciding official is a police, that police should be other than the arresting officer or an investigating officer.
Well, I don't think, that is what happens in practice, because I've had discussions, with the arresting officer. They may say to them, can the person get bail? They say, well, that is not my function. You speak to the custody officer on that issue. But they would indicate what their position is to the officer. So if that is what exists in practice, I don't think that there is any great harm in having it stated.
Madam CPC, could we tweak the definition in respect of where the deciding official is a constable to provide generally that that constable would be other than the arresting officer or an officer involved in the investigation of the offense?
Yes, Madam Chair, we could adjust the definition
All right.
of the deciding official.
Yes. All right, then we would so adjust it, but I wouldn't want to place the rank for the, I would keep the ranking only in respect of the pre-charge regime, again for practical purpose. All right, so the recommendation of the bar in respect of the term, the use of the term, the deciding official, is partially accepted, and that we would tweak the definition to make it clear that where the deciding official is the police, then the constable would be a constable other than the investigating officer or the arresting officer. So it's a partial acceptance of the recommendation.
Recommendation, the definition of the term defendant.
Just a minute, please.
Oh, sorry.
Yes. Right. So we accept in part the proposal in respect of the definition of deciding official, where that deciding official is a constable, and that constable would be a constable other than the arresting or investigating officer, generally speaking. Right. And then in respect of the pre-charge regime, the constable would be a person at or above the rank of superintendent. And that's part of the additional safeguard to deal with those police officers who may become a little more exuberant at the lower level. Right.
Definition of the term defendant. It is unreasonable and unfair for a person not charged with a criminal offense to be referred to and treated as a defendant. It would also provide clarity if a clear distinction were made between defendant, restricted to persons charged with an offense, and, for example, suspect, restricted to persons arrested or detained without charge based on a belief that they committed an offense.
Madam CPC, I'm going to ask you to consider very deeply how we may accommodate, though I recognize entirely from a drafting perspective the ease that an umbrella term provides for the provision.
Well, Madam Chair, the objection to the term defendant is not, well, I didn't construe it as an objection to having an umbrella term. So we could consider an alternative umbrella term. We could substitute, for example, the term relevant person instead of defendant, if that is more palatable to everyone.
We leave this one for further consideration. You're right, it's not so much the use of an umbrella term, but we'll do a second round of alternatives that can be used. But I am particularly mindful of the drafting ease.
Madam Chair,
yes.
Can I just inquire, when a matter is brought before the...
Please speak in the mic, member.
When the matter is brought before the court on an habeas corpus application, that person who is seeking to be released, what is he described as?
Defendant.
He's described as a defendant.
Defendant or respondent.
In the present circumstances.
Look at part 56 of the CPC for me.
The CPR.
CPR, rather. Either 56 or
I know,
58.
I know you're dating yourself, Chair. I did the CPC as well.
Yes, yes. The white book. Yes.
The CPR,
Yes.
no.
Madam Wilkins, are you telling the people that I am old in the law?
I would never,
But
not at
certainly-
all, not at all.
Can you imagine? Member Campbell, my learned friend at the bar.
No one could ever say that.
we were in the system from the last millennium. Long before these reforms came on the book. Just pull up. I think it's part 56. Yes, I think it's 56. That deals with habeas corpus application. Somewhere between 54 and 56. Part 50. Who is pulling up the provision? Part 57? Somewhere between part 57? Is it defendant or respondent? Well, if you are applying for a writ of habeas corpus, you would be an applicant, not necessarily because you're not responding in those circumstances. But let's just check. I mean, on further thought, anyone who is applying for an order of the court is generally yes. It would be the person who has the body in custody, usually the lockup person, and then by virtue of the Crown Proceedings Act, the Attorney General may be sued also. Because the order that is made, the writ is directed to the person who literally has the body of the person to bring forward, if the writ is issued. Yes? You found it?
He was looking through, but I was going to propose that we look at it and
we can look
come
at
back.
it behind.
And come back. Yes.
Behind the scene and come back.
Yes.
Right. But it, off the bat, relevant person doesn't sound like it would cut it to me. All right. So we will defer this one for...
What I noted with Dominica was it said a person who is arrested and not charged. But in every other case where they were dealing with people charged, they did use the word defendant. I guess it's
Ms. Wilkins, I hope you take note that you don't oppose me so strongly as you did behind the scene. See, I'm taking tales out of school when we were going through, right?
Yes.
You recall?
Yes, I do.
Okay.
I do. But
all right.
I'm
just for peace sake, I relented. For peace sake, right? And now you will appreciate. Then the CPC wouldn't be in the. She would have dealt with it other than because it's now the kind of work to go through.
Well, is that
just
issue?
Take note for future reference.
I know the implication.
For
is
future reference, Ms.
disaggregating.
Wilkins. Madam Director of Law Reform, for future reference.
Okay. Duly noted, Chair.
We'll stick a pin here and resume next Wednesday. And I ask everyone to plan for a full day, unless the facilities are not available for a full day sitting. And between now and then, to my team, aided by the AGC, please let us look quickly. I'm spending the time to respond to some of the comments. The short response could be not accepted, but this is also a learning forum for persons who are tuned in and are watching eagerly. And that's why I've taken the time to respond a little more extensively than I normally would, because so much educating needs to be done on these matters. I didn't realize the extent of... Let me pause there and not complete the sentence. All right, so is there any other business? So we'll note we have gotten to page... Page 5? Page 6? At clause 2. So we're adjourning at the point of examining Jambar's submission on clause 2, and then the term defendant. Next meeting is what date? All right. I'll ask again, is there any other business to address? Mr. Foreman, please be reminded that I will ask you to respond fully to the constitutionality of the pre-charge regime in light of the provision for the entitlement to bail unless and the release conditionally or unconditionally to return for trial or other stage of proceedings. All right. All right. Will someone move for the adjournment of the meeting? Member Campbell? So moved?
Second.
Member Charles seconded. Very well. All right. Today's meeting of the Joint Select Committee appointed to consider and report on the bill entitled An Act to Repeal and Replace the Bail Act and to provide for connected matters is hereby adjourned until Wednesday, January 18, 2023 at 10 a.m. Thank you all.
Meet 6 young people doing great things to tackle poverty, inequality, exclusion, and crisis in Jamaica. They're part of teams leading game-changing solutions and valued partners in UNDP's Ready, Set, Great Youth Development Showcase 2020